Well, good morning, everybody. Thank you so much for being here with us today. My name is Katie Earle. I'm the coordinator of the University Express program, and I work for the Erie County Department of Senior Services. And we're joined here virtually today with Valerie Stanek, and we're super excited to have her back on such an important topic. We always really appreciate her time. So we do have some new folks here today, so I'm just going to quickly go through my little spiel here as we start our last week of University Express classes in the fall. So if you're new today, you've noticed that you've joined without your video showing and you're muted and can do nothing about it. It's not that you've done anything wrong. Those are just the settings for our program today. And you also might think that you're the only person here with us, but I promise you there are others. It's just that we're in an anonymous participation mode, so only Valerie and I can see everybody who's here with us today, or your names at least. And we are recording the session, so I'll try to post it on our website in the coming days if all goes as planned. So throughout Valerie's presentation, if you have any questions or comments, please go ahead and type those in our Q&A panel as soon as you think of it, and we'll try to get to those when we can and as many as we can in the time that we have here today. If you are new, you'll access your Q&A panel on the right side of your WebEx screen if you joined from a computer or laptop. Chances are it popped up when you joined us. It might be there now. You just have to click the arrow and expand that. Then you'll see your text box and you can send your questions right to me. You might also see on the lower right-hand side of your WebEx screen a box with a question mark in it. And then you can click on your Q&A, and if you're on a tablet or smartphone, poke or touch your screen. That will bring up your Q&A panel if you click on that circle with 3 dots. So we do hope you ask all the questions you have here today. All right. Whoops, didn't mean to go jumping into that so quickly. I'd like to thank the sponsors of our University Express program. It's my Department of Senior Services, Blue Cross Blue Shield of Western New York, Excelsior Orthopedics, and Wegmans for everything they do to help make this program possible. And as always, please contact us at Senior Services if you have questions about programs, benefits, or services, anything at all. Please give us a call. We're at 858-8526. All right, so I will introduce Valerie to you. Valerie Stanek is an attorney practicing in the area of wills, trusts, estates, and elder law. In addition to practicing law, Valerie is a certified financial planning professional focusing on investments, retirement, and estate and long-term care planning. She lives with her husband and her Morky Alfie in their newly emptied nest in Amherst, New York. Valerie, thank you for being here today. The floor is yours.
Thank you so much, Katie. I appreciate it. Good morning, everyone. I really enjoy giving these presentations. Unfortunately, I am less likely to be as amusing as I am in person when I do it virtually, but that's okay. Feel free to ask questions. So this topic is, should I turn my assets over to my children? There are a wide variety of ways that people do that, and we're going to get into some of those. And the reason that this topic is one that comes up so frequently is it's one that my clients ask me about almost every time I meet with a client. So the topic begins with prioritizing your objectives. So first of all, before you can decide which of these strategies might be appropriate for you, you need to ask the question, what am I trying to accomplish? What is important to me? So we're going to talk about some of the objectives that might be served by using these strategies, and then the pros and cons of using them. One of the strategies that we'll talk about is a power of attorney. Now, a power of attorney doesn't literally sign your assets over to anyone, but what it does do is sign your authority to move your assets around, to make transactions on your behalf. So to a certain extent, although it isn't a transfer of an asset, it is a transfer of your authority. And we'll talk about the pros and cons of powers of attorney. The next thing that we're going to talk about is just giving your assets away, gifting, and what is good about that, what is bad about that, what works, and what can be a possible place where you might trip up by gifting things away. What about putting your children's name on your assets, including them in joint ownership? We'll talk about joint accounts and joint ownership of real estate and what some of the pitfalls might be there. we're also going to talk about life estates. I'm not going to get into it quite yet, but later I'll talk about it in more detail. But a life estate is basically a way of putting a beneficiary on your home. And we'll talk about how that works and what the pros and cons might be of that. We're going to talk a little bit about trusts at the end and why you might need a trust, why you might not. And then I will conclude and summarize and wrap up. Katie, thank you. So first of all, as I said, you need to have a sense of what your objectives are. You may have a multitude of objectives. You may have all of these objectives that I'm about to list, but what you need to do is choose which one is most important to you. And the reason you need to do that is because sometimes these strategies that people use to preserve and pass on their assets to their heirs are in conflict with each other. If you choose one, you're taking away from another. So making a list of priorities as to what is most important to you will help you in determining how to set up your strategies properly. So what are those objectives that you might have? Well, transferring assets can help you minimize the delay and expenses associated with probate and the administration of your estate. Now, people will talk to me and ask me exactly what probate is. Probate is the process that you go through with court supervision of transferring your assets from your ownership to your heirs after you pass away. Very important to remember that probate involves court supervision. Under certain circumstances, having probate supervise that process can be helpful. But in a lot of cases, what it is unnecessarily expensive and unnecessarily long. So a lot of people have minimizing or avoiding probate as one of their strategies, one of their primary objectives. Another objective is to prevent conflict among your children. If you have assets that have been transferred or that have been set up to be transferred in advance, you may have less arguing among your children because there's less confusion and less hard work to be done in transferring your assets after you pass away. For some people, for fortunate people who have very, very large estates, we're talking about over $10 million. Minimizing your estate taxes is an important strategy, and a lot of transferring happens for the purpose of avoiding estate taxes. For most of us mere mortals who are not likely to be passing on over $10 million to our children and grandchildren, we still want to do some tax planning. We want to avoid capital gains taxes, and we want to avoid income taxes, or at least minimize those to the extent possible. And some of these transfer strategies do accomplish that, but some of them, as I'll get into a little bit further, actually end up costing additional taxes that you weren't planning on. You may also want to be transferring assets in order to qualify for VA or Medicaid benefits. That is a very common objective that I also hear. And certainly we transfer assets because we absolutely want to have control over who gets what and when. So, for example, if you have a beautiful set of wedding rings and you definitely want them to go to this particular granddaughter, doing a transfer of that asset during your lifetime is one way, of course, of accomplishing that. So these are just are the main objectives that people identify as what they're trying to accomplish in transferring assets. So our first strategy that people use is to transfer not an actual asset, but their authority. So what about a power of attorney? Do I really need a power of attorney? First of all, let's identify what it is. A power of attorney is a document that gives authority to someone else to act on your behalf in transacting financial matters, in doing financial transactions. Broadly speaking, there are two types of powers of attorney. One is a durable power of attorney, which is valid and usable immediately after you execute the power of attorney. In other words, your agent could the next day take the power of attorney down to the bank, get their name put on the account, and transact, you take money out of your account, even though you are, perfectly capable of taking care of that yourself. Then there is the springing power of attorney that only springs into action if and when your doctor says in writing that you are incapacitated. So the objectives that are addressed by the power of attorney is to have someone be able to take care of your financial transactions if you're incapacitated, or durable power of attorney if you're just out of town or unavailable. So what could go wrong? What are the cons of using that? First of all, unfortunately, we see this an awful lot. Uh, Financial elder abuse is often transacted using a power of attorney. In other words, the agent under your power of attorney could steal your money. So when you execute a power of attorney, it's very, very important to trust your agent under your power of attorney, and in some circumstances, limit the power of attorney so that it limits the ability of an agent to steal from you. The only way to get your money back, if you execute a power of attorney and someone takes the money and does something with it, the only way to get it back is to take that person to court. If you have made a child, for example, your power of attorney, what are the chances that you're really going to sue your child and take them to court to get the money back? People do it, but it's a very, very, ugly and expensive, time-consuming, and heart-wrenching thing to have to do. Also, powers of attorney can cause serious disputes among children. If you have 3 children and one of your children is your agent under your power of attorney, I have seen it over and over again where the other children are very suspicious and very uncomfortable with one of the children having that kind of control. There are ways to mitigate that. There are ways in using a power of attorney to address that issue, but it's an issue that you need to be aware of before you execute a power of attorney. You should be thinking of all of these pros and cons so that the power of attorney is executed properly. One of the, in my opinion, a bigger con is to not have a power of attorney at all. And then your assets are locked up if you become incapacitated, and pretty much no one can get at them without going through some very, very expensive and timely or time-consuming hoops. Okay, thanks, Katie. So that's one tool in regards to handling your assets. What about the idea of gifting? Just giving something to someone. Now, a lot of people will gift away their assets with the sort of understanding that although I'm putting this in my child's name, it's really mine, and if I need it, I'll be able to use it for whatever use I need for it. So, what are the objectives that are accomplished by gifting assets away? One of the things that putting someone else's name on your asset accomplishes is to completely avoid that issue of probate, the delays and the fees, the expenses, the attorney's fees, those kinds of things that are associated with going through probate. Another objective that is met is to help qualify for veterans benefits or Medicaid benefits or those types of benefits that have a means test. Certainly, if you have a very large estate, it could save on estate taxes if you have gifted assets away, and a lot of wealthy individuals use gifting quite extensively. Okay, Katie. Katie, there we go. Uh, so what could go wrong? What are the what's the downside to gifting? First of all, when you gift something away, you have given it away. It's no longer yours. So legally, you lose all rights to the assets. If then you want that money back under the understanding that although I put it in your name, when I need it, I want to be able to get it back and use it, you have no recourse. If you've gifted it away, it belongs to the other person, and you really can't you can't object. Um, Also, when you're talking about a house, you know, people will often gift away put their children's name on their house, take their name off it, with the idea of preserving that asset if they need to go into a nursing home. Well, unfortunately, then when you pay taxes, you may very well lose the star exemption that you have. So the property tax break that you have under New York State property taxes may be lost. You may also fall into what I refer to as the look back trap. If you gift away a house, other real estate, or an account, and then you need to apply for nursing care within 5 years, Medicaid is going to penalize you by the amount that you gifted away within that 5 year period. So you won't qualify for Medicaid benefits, and you know that could put you in a very serious bind in regard to your nursing home care. You would lose a step up in basis. Let me talk a little bit about step up in basis here. Some people are not aware that, let's say that you bought a portfolio of stocks or you bought a house, and either that portfolio of stocks or that house was purchased at $50,000 and now it's worth $100,000. If you die with that portfolio of stocks or that house in your possession, your heirs would receive it at $100,000 at the market value at the time of your death, and they would not have to pay capital gains taxes on the value of that portfolio or that house that represents growth. So if, on the other hand, you gift that asset, for example, the house, you bought it at $50,000, you gift it when it's worth about $75,000, and then when you pass away, it's worth $100,000, and your heirs decide to sell it at $100,000. They would have to pay capital gains taxes on $50,000. In other words, the entire growth value from the date that you purchased it to the date that you passed away. So, or actually the date that they sell it. So they lose what they normally would have had, which is a step up in basis at the time of your death. So basically, that strategy would have cost additional capital gains taxes that a lot of people don't consider when they turn their assets over to their children, when they gift their assets to their children before they die. You may also lose that asset to your child's creditors. If you gift something away to your child or to your heir or to anyone else, if they have a creditor that comes after them, you could end up losing that asset, or they could end up losing the asset. Now, a lot of people will say to me, well, you know, my child's doing very well financially. My child is very responsible. They don't have any, you know, any issues. I don't really expect them to have any, you know, any creditors. They're not in business for themselves. So why should I be worried about that? The reason you should be worried about that is under our current medical health system, if somebody becomes seriously ill or gets in an accident and they exceed the amount that their health insurance will cover, and they end up with millions of dollars of you know, of medical bills. Those medical bills are, you know, the hospital or the doctor becomes a creditor, and so those assets are vulnerable to the creditors of anyone to whom you give those assets. The other thing that can happen is your child can get divorced or your heir can get divorced, and there are circumstances under which the divorce may end up taking some of those assets away in the process of the divorce settlement. The asset may also be subject to gift taxes if you gift it away. Not likely for most of us mere mortals, because again, you would have to be gifting away more than $10 million, but still something to be considered for some people. Okay, next. So let's say that I don't gift something away outright. I don't just give it away. What I do is just put my child's name on it, or my heir's name on it, in my niece's name on it, whatever, in joint name. So now it's a joint asset instead of being just my asset. Some of the objectives that may be met by joint ownership is that owning an account or a house or whatever the case may be completely avoids probate. If you own a piece of property jointly, at your passing, that property goes directly to the person who owns it jointly with you. So it's gone. And it does not go through probate. So that's a good thing. Both owners have easy access and equal rights to the account. So it makes things convenient if your child is paying bills for you, or it makes things convenient if your child wants to, call the utilities or the tax, the tax office and have questions or what have you. So easy access, equal rights. Those can be very, very powerful reasons for putting something in joint name. However, as usual, there are always downsides to doing that. So what could go wrong? Both owners of real estate have to sign for a mortgage or to sell the property. So if you put your child's name on your house and you want to sell it, but your child decides, you know what, that's my childhood home, I don't want it to be sold, we're not selling, you can't make them sell it. So you have just given away your power to make decisions and to do, to execute transactions involving that real estate. So if you don't have a child who will do what you tell them, this could end up being a problem. Also, if you own an account jointly, very often people think that 50% of that account, if it's owned with my child, should then be protected. If I need to go into a nursing home, Medicaid should only expect me to spend half of that account. That isn't the way that that Medicaid looks at it. If you need to go into nursing care, 100% of that joint account is considered to be yours, and you will be expected to use the entire account. So there is no protection for that account if you need nursing care. This is another situation where you would lose the step up in basis. Just like gifting away your house, if you put your child's name in joint name on the house and then you pass away, the child would pay capital gains taxes on the growth from the time that you purchased the house to the time that they sold it. Whereas if you didn't put your child's name on it, that capital gains tax would have been preserved, because they wouldn't have had to pay any taxes on any of that growth, except for from the moment of your death, the day of your death, to the day that they sold the house. So the capital gains tax would be significantly reduced under most circumstances. Again, if you put an asset in your child's name jointly, it's considered 100% theirs as well as 100% yours, which means you could lose a portion of that asset or even the entire asset to your child's creditors. Your child could take the asset if their name is joint on it. They have full ownership of it. So you put their name on your savings account, for example, or your CD. they can walk into the bank and take it. The other thing that can happen is you can lose it in their divorce, or, as I said, from their creditors. And that transfer may also be subject to gift taxes if you are talking about very, very substantial gifting. Okay, next. All right. So the next question is, should I keep a life estate? So this is another way of transferring your house. This is specifically for your own residence. It doesn't work. It's not permitted in New York State for rental property or other real estate. But what is a life estate? Well, a life estate is a transfer to your children of the value of your house after you are gone. So what you retain is the life tenancy. So basically what that means is you have all of the legal rights to the house from the time that you do the transfer until the day of your death. That house is legally, you have access to it, you can use it, you can alter it. You have to pay the mortgage, you have to pay the taxes, you have to pay the insurance. So during your lifetime, for all intents and purposes, it's yours. However, at the moment of your death, it becomes your heirs or whoever it is that you put on as the remainderman on that deed. So they become owner, but they only become owner in the future. They only become owner at the moment of your death. So it's very much like putting a beneficiary on your house. So the objectives that are addressed by doing a life estate is you keep the legal right to live there. You avoid the probate process because it goes directly to them as if they were a beneficiary. It helps you to qualify because you don't own that asset anymore. They technically do. You could qualify for veterans benefits or Medicaid benefits if you need long-term care sooner. You could save on estate taxes if that's an issue for you. And even though you've, to a large extent, transferred the property to them, you still retain the step up in basis. So at your death and at the point at which they decide to sell the house, they don't have to pay all of the capital gains taxes on all of that growth from the time you purchase the house until the time that they sell it. They only have to pay capital gains taxes on the growth from the time you die to the time that they sell it. So that, in most cases, saves an awful lot in taxes. Okay, Katie. So that sounds great, and it works in a lot of cases. A lot of people do this transaction. It's something that that I do for people all the time. But you want to bear in mind some of the things that can happen. You can fall into that look back trap. So if what you're doing is, if what your objective is to qualify for Medicaid benefits, and not lose the house, to preserve the house if you need long-term care, you do need to do this life estate transaction 5 years before you apply for Medicaid, because we do have to always bear in mind that 5-year look back. The value of the life estate may be subject to a Medicaid lien. Now, what that means is instead of the entire house being subject to a Medicaid lien, just the value of your life estate portion, your life tenancy, is subject to a Medicaid lien. Now, Medicaid doesn't always do this. In fact, they often don't, because it usually isn't worth it. Because the value that we're talking about here, let's say your house, let me give you an example. Let's say your house is worth $200,000. At your passing, your house may only be, for Medicaid purposes, worth like $20,000, because the older you get, the less value you're retaining in that house, because you're retaining just that little slice of time in the house from the time that you put it in the life estate to the time that you die. And of course, as you get older, that sliver of time is getting smaller and smaller, which means that your value of the house is getting smaller and smaller. the majority of the value of the house is actually considered to be owned by your children. So the only thing that Medicaid can put a lien on is your little sliver of the value of the house. So instead of putting a lien on your $200,000 house and pulling all of that, that value back into the Medicaid system after the house is sold, Medicaid can only put a lien on, for example, about $20,000. So you're preserving the vast majority of the value of the house. But you want to be aware that there could be a Medicaid lien on that small sliver. The value of the life estate remains in the estate for tax purposes. So again, the value of that little sliver could be subject to estate taxes if your estate is worth over $10 million. The value of the remainder in interest is also subject to gift taxes. So in other words, what you gave away to your heirs by setting up the life estate was a gift. And it may, if you have given away $10 million or more in your lifetime, that gift may be subject to gift taxes. Okay. So let's talk about a TOD, a transfer on death account. We're not talking, this doesn't work for real estate. This is, life estate is for real estate. A transfer on death is for bank accounts, brokerage accounts, all of the accounts that you hold that are not IRAs. As I'm sure you're aware, an IRA, an annuity, a life insurance policy, all of those things have a beneficiary on them. Well, a lot of people are not aware that your savings account, your checking account, your CD, whatever you have, that your brokerage account that is not an IRA, all of those can be set up to have a beneficiary on them. And the objective that is addressed by a transfer on death account is the transfer on death account avoids the delays and expenses of probate. So in other words, you put a beneficiary on your checking account, and when you die, although the person who is the beneficiary does not have access to that account during your lifetime, at the moment of your death, that account can be claimed by the person who is on it as beneficiary. Therefore, it doesn't have to go through probate, which eliminates a lot of expenses and saves a lot of time. During your lifetime, you keep control. Your beneficiary has no access to it. It is your account, just like your IRA. And also,
Oh, Valerie, are you there? I think we might have lost you.
brokerage account goes to your heirs free of capital gains tax. So transfers on death can be a very useful tool. Okay, Katie. So what could go wrong? A transfer on death account does not save you from having the assets in your estate at your death, and those assets count against you for estate tax purposes. The assets also count against you when you apply for veterans benefits or Medicaid benefits. So there is no protection of those assets for the purposes of taxes or for the purposes of qualifying for Medicaid in the event that you need long-term care. Okay, next. So what about a trust? Trust can be a very handy tool. What a trust basically is you setting up a legal entity, sort of like a business, where you can take an asset and take it out of your hands and put it in that trust so that the asset is no longer yours, but the trust document gives all of the instructions about how that money can be used. So you have control over the money to the extent that the trust was written so that the trustee has to follow your rules with how the money is used. But you no longer have control over the money once it's in the trust, especially if it's an irrevocable trust. And we'll get into irrevocable versus revocable trusts in a second. So basically, the idea is to set up an entity that owns your assets instead of you owning the asset. Okay. The objectives that are addressed by oh, I'm sorry. Can we go back one? There we go. The question is often, is a trust worth the expense? I get people saying to me, well, isn't it really expensive to administer a trust? Isn't it really complicated? Doesn't it cost a lot to write a trust? The answer to that is, of course, this is the lawyer's common answer. It depends. Some trusts are literally free. There are trusts that, for example, that I put in a client's will that are just one paragraph. They're very straightforward, and it doesn't cost them any more than the will without the trust. For one example is what I refer to as a pet care trust. A pet care trust gives a small amount of money and instructions to someone for taking care of your pets when you pass away. There's no charge to add a pet care trust to a will. So a trust is it can be that simple. Basically, it's a way of controlling what happens to something that you own after you're gone and for a period of time after you're gone, right? Or it can be quite complicated, and they can cost in the tens of thousands of dollars, just depending on what you're using it for. Most simple trusts are, in the $1,500 to $5,000 range in my law firm anyway, because they tend to be fairly straightforward. So what are the two primary types of trust? Revocable and irrevocable. And now if we can move forward. Thank you. Okay, a revocable trust addresses the following objectives. It avoids the delays and expenses of probate. So anything that is owned by the trust goes wherever the trust says that it goes at whatever time the trust says that it goes after you pass away. You keep control during your lifetime and after your death. In other words, you can put conditions and you can put time frames in a trust that you can't really put in a will. So, for example, you can say, I want any minor heirs to receive, for example, my grandchildren, to receive their share of the inheritance, a percent at age 21, a percent at age 25, and a percent at age 30. You can also put conditions in a trust. So you can say that my grandchild only receives his share of the estate if he graduates from college. With you can be really mean and you can say he has to graduate with at least a 3.0. So you have a lot of what we refer to as dead hand control over what happens to your assets after you pass away in a trust. So you can have timing, you can have conditions, and probably just as importantly, it protects the assets from creditors. So your beneficiary's creditor cannot reach into that trust and take the money out of the trust. So very powerful document. Now with a revocable trust, it is what it says, it's revocable. You can change it. You can be a trustee. You can control completely during your lifetime, and you can end the trust at any time. You can change your successor trustee. You can change the beneficiaries. You have total control. Next slide. So what could go wrong? If you transfer assets to a trust, you could lose that step up in basis depending on how the trust is written. The assets will remain in the estate for tax purposes, because if you can control everything about it and you can revoke it, then the IRS considers you didn't really give it away. For tax purposes, it's still yours. The assets, again, for the same reason, remain subject to a Medicaid lien. So those assets are considered available to you if you need long-term care. And that's makes sense if you think about it. Literally, those assets are accessible to you at any time and in any way that you like. There are initial trust expenses, and there can be some ongoing trust expenses, especially depending on who the trustee is. Next slide. An irrevocable trust removes assets from your estate completely for estate purposes, and the reason that it does, the IRS recognizes it as you no longer owning the asset. In an irrevocable trust, you have no control, and you can't revoke it, and you can't be the trustee. So if you want the IRS to recognize this, or if you want Medicaid to recognize this as a trust that protects your assets from taxes and to make you eligible for Medicaid if you need long-term care, you need to let go of those assets, and you need to no longer be in control. So you're in control to the extent that you write the trust, or you have an attorney write the trust for you. You write the rules, you say what is going to happen to the money exactly. You can actually even receive income coming out of the trust, but you can no longer terminate the trust. You can't access the principal of the trust. So it removes the assets from your estate for the purposes of estate tax and benefits qualification for Medicaid. It avoids probate. It provides, again, like the revocable trust, it provides detailed control after your death in terms of timing, in terms of conditions for receiving the inheritance, and in terms of creditors. And your heirs keep that step up in basis at your death. So definitely a lot of powerful, strong help in preserving assets in an irrevocable trust. So what could go wrong? Well, as I said, it's irrevocable. So you may, life has a way of throwing curves at us. If you might change your mind down the road, you need to be aware that that revoking an irrevocable trust is not easy. By the way, you would think it's impossible, but it's not. You can actually revoke it, but you have to go through the process of getting signed waivers from all of the people involved, all the beneficiaries, the trustee, and you as the grantor. You need to also be aware that you could fall into the look-back trap, and there are initial and ongoing trust expenses. One other drawback that I hate to even mention is you have to be able to trust your trustee. That's very, very important. Just as important, maybe more so, than a power of attorney. Okay, next. Okay, so I'm going to take some time to answer some questions if anybody has any. Let me just encourage everyone to make a plan. Make sure that you are making a plan based on your objectives. Also, try to make sure that your plans in regards to transferring assets to your heirs do not cause you tax problems, and also that your financial plan, the way that you have your assets set up, the way that you have your beneficiaries set up in your will, and the way that you have your beneficiaries set up in your IRA are not in conflict with each other. I see that all the time. So you want to be sure that you have a plan. You want to be sure that you've gone over it carefully, and that your attorney and your financial planner, I do both, so I see both sides of this, are not at cross purposes with each other in your two different types of plans. And make sure that you definitely have a will. You definitely want to have a healthcare proxy. The reason for that, for both of those things, being that what happens, and this is another seminar altogether. What happens when you don't have a will is your assets don't always go where you want them to go, because New York State has a will for you. And the way that they have the will set up is not always the way that, the default will set up is not always the way that people want things to happen. If you don't have a healthcare proxy, that can cause life-threatening delays at the time that you are getting care. I also encourage you to consider a power of attorney, but just depending on your circumstances, whether that's absolutely necessary or not. This is my contact information, and please feel free to call me with questions. I do take phone calls. I do make initial appointments with people that I don't charge for. So there is a complimentary initial consultation with me. If you would like, or if you just have questions for me, feel free to give me a call or send me an email. Any questions?
Thank you, Valerie. We have quite a few questions here.
Oh, Katie, I can't hear you. I'm sorry, go ahead.
Okay, can you hear me now?
Yes.
Okay, good. It's like we're in a commercial. Thank you so much. Can you please read your phone number and your email for folks who are calling in, please?
Oh, yes, absolutely. My telephone number is 716-913-0509. And the email address is my V Stanek, so V as in Victor, STAN as in Nancy, EK at ESQCFP.com.
Okay, thank you. So yes, quite a few questions. We'll be jumping around a little bit here, but let's get started.
All right.
The first question I'm seeing is, in the life estate, can your heirs' creditors make claims against the property?
The heirs' creditors can only make claims against the property after you have passed away and it becomes theirs. So during your lifetime, they have no recourse, because their ownership is what we call a future interest, which means that there's no value there until the date of your death.
Okay, thank you. Next question. When would you file the gift tax return if you set up a life estate? In that year, what happens if the gift tax return is not filed?
You would file, yes, you would file a gift tax return in the year that you do the life estate. There are no taxes due unless you have gifted away more than $10 million over your lifetime. So if this is the first time that you've gifted away a large amount of money in any one year, you do have to do a gift tax estate. However, it won't have any tax consequences for either you or for for your heirs who have been named as the remainder on the life estate. So nobody's going to have to pay taxes in that year. You do have to do the gift tax return. If you don't do the gift tax return, there are no serious consequences. In fact, it's probably not going to be noticed unless you're audited. And even if you were to be audited, you're not really going to owe any taxes. It's not like you're trying to cheat the IRS. They're just going to make you, they'll make you file it, because what they want to do is keep track of how many gifts you give, so that if you do reach over $10 million, they can tax you for any gifts over and above that amount.
Okay, thank you, Valerie. Next question I'm seeing is, if I put my kid's name on my house or do a life estate, can they evict me?
If you put your kid's name on the account with you, or on the house with you, they cannot. If you turn the house over to your children and you put just their names on it, yes, they can evict you. With the life estate, they absolutely cannot evict you.
Okay, thank you. Next question. I have a CD in my name. How would I list beneficiaries on it?
Yeah, what you would do, you would make it a transfer on death account. What you would do, that's what most financial institutions call it. Some of them call it something else, but it means the same thing. What you would do is go to your bank and you would ask them to make this a transfer on death account, and if they don't know what that means, if that's not what they call it, you can just say, I'd like to put a beneficiary on this account. And what they will do is change the account ownership, and they'll make it a transfer on death account or whatever they call it. And they will put your children's name on it. What that will probably mean is that your account number will change.
Okay. Thank you. That actually answered somebody else's question. So we have a couple folks who are wondering if you can further explain the step up in basis, please.
Sure. It's a complicated concept, and I do this much better if I have a blackboard. Let me try to explain it this way. When you buy something, it's worth the money that you use to buy it is called basis or principal, the initial money that you put in. So when you buy your house and you bought it for $50,000, the basis is $50,000. If you have a step up in basis, what that means is, let's say at your death, that house, that $50,000 house, grew to a $100,000 house. So at your death, it's worth $100,000. The growth from 50,000 to 100,000 is now, without the step up in basis, that would be taxable. That would be capital gains taxable. But because the IRS gives your heirs a step up in basis on that house, it means that they take the original basis of $50,000 and they say, okay, we're going to say that at your death, the value of the house was 100,000. We're going to allow your children to say that their basis in the house is the entire $100,000. So they don't have to pay taxes on all of that growth in the value of the house from the time you purchased it to the time of your death. So now the basis for your heirs is $100,000, which was the value at your death. And then if they hold on to the house for another few years, now it's worth $110,000 and they sell it, they will have to pay capital gains taxes on $10,000. So the growth from the time that they inherited it to the time that they sell it is $10,000. They'll have to pay capital gains taxes on $10,000, not on the entire $60,000 all the way down to your basis, which was $50,000 when you bought it. Does that help?
Maybe. Thanks, Valerie. It's a lot to keep straight. Okay, next question. What is the New York State law about gifting up to $13,000 a year to our adult children?
Yes, actually, that is that's also an IRS law, and that number has gone up to $16,000 actually. And what that is referred to is that's your gift tax exemption amount every year. The only thing that you're saving by not giving more than $16,000 is the headache of having to report or having to file a gift tax sheet, an extra part of your tax return in any year that you gift more than $16,000 per person. You have to file a gift tax return. Okay, if you gift less than $16,000 per person in any given year, then you don't have to report it. The point being that over $16,000 gifts are not so horrible. It's just a matter of filing a return. You won't have to start paying taxes on a gift until you gift away in any given year. Over the course of your lifetime, you have gifted away more than $10 million. So for most people, you don't really need to worry about it. You can gift away $100,000 in any given year. You just have to remember to report it at the end of the year when you do your taxes.
Okay, thanks, Valerie. We just had a question coming in that says, can a gift be given to anyone, or is it just to your children for the $16,000 exception?
For the exemption, for the $16,000 exemption, the gift can be to anyone. It doesn't need to be a family member. It can be a friend. It can be, it can be to anyone.
Okay, thank you. We have a lot of questions here. Is it okay if we keep working down the list?
Sure, go right ahead. I have time.
Okay, thanks. Next thing, does the Medicaid 5-year look back vary from state to state?
No, the Medicaid 5-year look back is a federal number.
Okay, good. Thank you.
That's Medicaid. That's a national number.
Okay. Next question. Can a childless adult leave a trust for born or unborn cousins or even unborn grandchildren?
Yes. Yeah.
Okay, that was easy. Next, we have one son who is listed as primary beneficiary. Is it okay to list his minor children as contingencies? Should we leave them off, trying to avoid probate? Thanks.
Yeah, that's one of the very useful things about a living trust is that when you have minor beneficiaries, you don't really want them to receive that. Most people anyway don't want them to receive the money the way that they will receive it if they're on the account as a contingent beneficiary. You certainly can name them as a contingent beneficiary, but I wouldn't myself. And the reason for that is that when they hit 18, they get a great big check. And that usually is really bad timing. So you usually don't want an 18-year-old to have enough money to go buy a Ferrari. Not a good idea. Now, having said that, if that's okay with you, then you can certainly do it that way. I would prefer myself to use, at the very least, I would use a Uniform Gift to Minors Act account to leave money to a minor, because at least then they don't receive the money until they're 21. But in a trust, you can ask the trustee to manage the money for the minor until they reach whatever age. You can instruct the trustee to pay for their college education. You can instruct the trustee to provide for, a car when they reach age 21. I mean, you could be very specific in how the money gets handed out to a young person over the course of however many years that you can say, give them an income beginning at age 21 and over the course of 10, you have a lot of control.
Okay, thanks, Valerie. Next question. If you have a trust, would you also suggest a life estate for your house?
Yes. It's under most circumstances, not always. It depends. There are always things to consider. You would need to, you'd need to look at the specifics of how all of your assets are set up, et cetera. But if you have a trust and your house is not in the trust, which sometimes putting a house in a trust is cumbersome. So using a life estate is a much more convenient way of handling the transfer of the house and to avoid probate with the house.
Okay, thank you. Next, where is your office located?
My office is located at 6400 Sheridan, which is the corner of Sheridan and Transit Road.
Okay, easiest question of the day.
Yes.
Next we have, is your will registered somewhere?
You can file your will with surrogate's court. And some people do that. In this day and age, very often what people will do is leave their will with their attorney and their attorney keeps it in a fireproof safe. Most of my clients leave their wills with me. If they prefer to have me file it for them in surrogate's court, I will.
Okay, thanks, Valerie.
Mm-hmm.
Several more questions here. The next one is, you said Medicaid can take 100% of your joint account. Is this true for a joint account with your spouse? If so, shouldn't we try to keep accounts solely owned?
Well, the thing about your assets and Medicaid is that Medicaid considers assets that are owned by the couple to belong to both of them. So whether your account is joint or whether it's solely owned, Medicaid considers your account to be available to your spouse for his or her long-term care needs. Now there are ways of avoiding that. But the strategies that people use to avoid that, I'm not going to get into that in a lot of detail right here, but the strategies that people use to avoid that are not foolproof. And Medicaid, they sometimes work and they sometimes don't, depending on how hard Medicaid wants to push back. So gray area. So yeah, planning requires, I recommend that people plan assuming that Medicaid is going to look at your assets as belonging to your spouse and vice versa.
Okay, makes sense, thanks. Next, can you legally allow your partner to stay in your home should you die, but not leave the home to their children?
Yes, you can set it up that way. It might require a trust depending on the circumstances, but yes.
Okay, thanks, Valerie. Next one. I understand that if we pay for our grandchildren's medical expenses, it doesn't count towards annual gifting limits. Would this be true for orthodontic work then? Thank you.
I am sorry, but I don't know the answer to that one. I'd have to look that up. If you give me a call and ask that question to me privately or email me, that would be fine. I will look it up for you and get the answer.
Okay, thanks, Valerie. Next one. Can you set up a life estate on a manufactured home but do not own the land?
I don't believe so. Again, that's one that I'm not 100% sure of, but I don't believe so. I think that would have to be set up. That would have to be set up differently. I do believe that you can. I don't know for sure. Again, this is one of those ones, I think I know the answer, but I don't want to guess. So go ahead and, again, if you would like to, give me a call and I can double check that for you.
All right, thanks, Valerie. Got about a handful here and then we'll let you go, if that's all right.
That's fine, sure.
Next question. Good. If you keep your house in your own name, can the nursing home take it?
I hate this answer, but I give it all the time, and it depends. What they do, they don't exactly take it. What happens is if you are living in your home together with a spouse and you need to go into a nursing home, your spouse can stay in the house and will keep the house. If then you pass away, your spouse still owns that house. There's no lien on it. So the house is exempted if there is a spouse living in the house. If, on the other hand, you are single and you're living, in your own home when you go into a nursing home, your house is not considered an asset until you pass away. So what happens is the house is just sort of left there. You're not required to sell it in order to get Medicaid assistance for nursing care. But what Medicaid can do is put a lien on it, and after you pass away, the house will be, and when the house is sold, whatever value whatever amount that Medicaid paid for your care, they can claim back from the house. So if the house is worth $200,000, Medicaid paid $100,000 for your care, only $100,000 will go to your heirs. The other $100,000 will go back to Medicaid.
Okay, that makes sense. Thank you. Mm-hmm. Next, would you recommend a deed transfer or real estate trust?
I'm not real sure what, it depends on for what purpose, but A deed transfer is what we use to set up a life estate. A real estate trust, in order for the house to be owned in a real estate trust, you would need to transfer the house by deed into the real estate trust. So it depends on whether we're putting the house in trust or whether we're going to hold the house in life estate, which way you would do the transfer.
Okay, thank you. Coming to the end here. Next, I'm seeing, is the child responsible, or is it considered income for the person you gifted it to?
I'm not sure what we're referring to, but I can take a guess at what you're getting at. The child, if you gift an asset, for example, if you put your child's name on a house in life estate, the child is not responsible for that house and does not have access to the value of that house until after you die. If you gift a house outright to your child, the child is responsible, and the child is potentially, if somebody gets injured on that property, the child would be liable for that injury. The child would be the one who would be the insured on any insurance policy on that house. So it depends on how you transfer property, whether they would be liable for it. Now, in terms of taxation, when you gift, as long as you're not gifting away more than $10 million in your lifetime, if you gift a piece of property or an asset to your child, there is no tax consequence to you or to the child.
Okay. That person said they were referencing the $16,000 you can give each year.
Oh, yes. The $16,000 that you give each year, there is no, if you give $16,000 or less, there is no tax consequence, and there is no responsibility for on the child's part to report the gift. If you give more than $16,000 a year, so let's say you give your child $100,000, you have to report it on your taxes. You do not pay taxes. The child does not have to report it, and the child does not pay taxes.
Okay, thank you, Valerie.
Mm-hmm.
All right, next, does a will override a beneficiary on an account?
No, it's the opposite. The beneficiary, and this is a problem that I see all the time. People will have one beneficiary on their IRA, for example, and they will have other beneficiaries on their will. And when I tell them that what's going to happen if they pass away is the beneficiary on the IRA will supersede the will. So in other words, the only way for your heirs to get at the money in your IRA is if assuming that there's a beneficiary on it, is through the company. So they would go to the financial institution that's holding the IRA, and they would make a claim. What's in the will would be totally irrelevant. The financial institution doesn't even want to see the will. All they want to know is who's the beneficiary on the account. If you really didn't want your eldest child to receive any of your inheritance, but your eldest child, you forgot to change the beneficiary on your IRA, and your eldest child is the beneficiary on your IRA, and your will says only my youngest child is going to get my money. Anything that was in your IRA is going to the eldest child. Anything else that did not have a beneficiary on it will go through the will, and your youngest child will get it. So the beneficiaries supersede the will.
Good to know, Valerie. Thank you.
Mm-hmm.
All right. 2 more questions here, and then we can be done. Does a revocable trust automatically become an irrevocable trust upon your death when the newly named trustee becomes the trustee?
Yes. It becomes irrevocable because the person who can make the changes is now dead, and therefore it can't be changed anymore.
Okay. Last question that I'm seeing is, I helped my daughter-in-law pay off her student loan. I paid to the financial institution, not her, but the loan was in her name. Should I file a gift tax return?
A really good question. That is another one of those things I'm going to have to look up for you. Please feel free to give me a call or email me with those questions that you'd like me to double check for you. Like I said, I think I know the answer, but I want to be sure that it is true in the case of I know if it were a medical bill, I know the answer, but for a student loan, I am not sure. I have to look that up.
Okay. Well, thank you, Valerie. And now I'm just saying thank yous. I have thank you for your time. Very informative session. Thank you so much. You've given me a lot to think about. Thank you, thank you, thank you. So Valerie, as always, we appreciate your time and you being on with us. And to everybody who's here, thank you. And I hope you have a great day.
Okay, thanks everybody.
All right.